of all, a big cheers to everybody who turned up at 8:45 for the academic session. You are heroes, all of us, and we are very happy that you made it. It's a particularly challenging slot directly after the Mozilla party right in the morning. But it's worth it because we have here a wonderful, at the moment still all-female panel on regulating artificial intelligence through the European AI Act. And I'm super happy to be the moderator. I'm Kristina Irion. I'm associate professor at the Institute for Information Law at the University of Amsterdam. And I would like to invite the panelists to shortly introduce themselves. Yeah? Mm-hmm. Shall we just go now in the order how we are sitting and you start? Here's the mic.
Good morning, everyone. My name is Rachael Olaitan Aborishade. I recently graduated from the VU Amsterdam. My track was international technology law, and I'm currently an intern at UNIDROIT. I work on digital assets and implementation with and compliance with international commercial law treaties. Yes. And so my paper, it's about companion chatbot vis-a-vis the EU AI Act. And I think I'll reserve some of my minutes to talk about it when I begin my presentation. Thank you.
Thank you, Rachel. And now we go to Emma.
Good morning. Thank you all for coming. It's an honor to be here. Thank you to my fellow panelists. I'm really excited to get started. My name is Emma Semaan. I'm a doctoral candidate at the University of Oxford's Faculty of Law. And I'll be looking at the AI Act through its co-regulatory technical standards.
Lovely.
Good morning. My name is Maria-Lucia Saiger, and I'm a postdoc at Freiburg University in Germany, not the Swiss Freiburg, but the German one. And I'm very happy to be here. I've recently, like 1 year ago, started to lead a interdisciplinary research group on the AI Act and AI regulation in Brazil, Japan, and the EU, and now I'm going to present part of this regarding the EU AI Act. Thank you.
Thank you to my fellow panelists and our moderator for being here and for starting the discussion. My name is Maria, and I am also a doctoral researcher, but at Leiden University, and together with Gianclaudio, we work on vulnerability and the way vulnerability is experienced both in relation to AI systems and social media.
I'm Gianclaudio, sorry, there was a long queue at the checkout of the hotel. But yeah, I work with Maria on this topic. Thank you.
So, thank you. And then we want to directly go into the session, and we will start with the presentation of Maria-Lucia on the AI Act implementation in different countries.
Thank you. Just going to check whether the presentation is there. Thank you so much. So AI stands as the quintessential disruptive technology. A prime example of this disruption has been DeepSeek. This general-purpose chatbot was developed by a Chinese AI startup, and how it arrived on the market illustrates that technological innovations in the AI sector may challenge the foundational structures of leading tech firms. From this perspective, AI aligns with other technological innovations, such as the letterpress, steam engine, electricity, and the internet. Each of these advancements has not only reshaped markets, but also significantly influenced societal behavior. But what does disruption actually mean? And what does it imply for regulating AI if we perceive it as a disruptive technology? Welcome to my presentation on navigating disruption, and in line with the theme of this panel, I will focus specifically on the EU AI Act. I will ask, what is the relationship between disruption, or the rumors thereof, and the law? And second, does the European AI Act successfully integrate the concept of disruption into the legislative framework? My argument is that the EU AI Act seeks to make technological innovations less disruptive through what I frame as multidimensional collaborative AI governance. Multidimensional collaborative AI governance is a complex form of knowledge creation and exchange, as well as trust building. I argue that the AI Act has the potential to create a regulatory environment that can adapt to rapid technological changes, and that the AI Act at the very same time may enhance legal and societal stability. But It will unfold this potential only if the involved actors critically engage with the underlying assumption of AI as disruptive technology. Let me start by clarifying the concept of disruption and by tracing its evolution from its origins to its current usage. Clayton M. Christensen was a professor at Harvard Business School. He introduced the concept of disruptive innovation in his 1997 book, The Innovator's Dilemma. With this term, he described technological advancements that replace existing technologies. These innovations, according to Christensen, lead to the creation of new markets while rendering former markets obsolete. Originally, disruption explained how innovations could destroy the competencies of established firms. Today, disruption or disruptive innovation is framed as the theory that influenced big tech leaders. Disruption has become a central topic in TED Talks and management literature and newspapers, and I'm sure many of you have encountered the term in various contexts recently. In its original sense, the concept of disruption has been criticized as a fearful notion driven by concerns that firms may fail in the face of innovations. Adrian Daub, in his inspiring book, What Tech Calls Thinking, has carved out that Silicon Valley has reframed disruption as a desirable force. Some might be reminded of the concept of creative destruction by Josef Schumpeter. It is important to note that from the outset, the concept of disruption described not only technological innovations, but also their impacts on markets and societies. However, originally, it did not extend to the legal realm, but things have changed. Disruption now encompasses potential impacts on the competencies of legislators and governments, especially in the context of technological advancements. What are the twofold normative assumptions of disruption today? First, disruptive innovation emphasizes speed and scale while pushing for rapid and large-scale changes. But it leaves in abeyance what this future will actually look like. So it's kind of different to the term of transformation, for example. Second, disruption has fostered an anti-regulatory tendency. It is grounded in the belief that technological innovation progresses too quickly to be effectively regulated. Technology is supposed to govern the world, to put it bluntly. We saw this dynamic when President Donald Trump, on the first day of his second term, revoked Biden's executive order on AI. He criticized this previous approach and I quote, onerous and unnecessary government control over the development of AI. But as we are in Brussels and not in Washington, what is the European way of doing with disruption? The EU AI Act, in its recitals, explicitly references the avoidance of a disruption of the market. And indeed, a potentially disruptive event influenced the drafting of the legal text, the release of ChatGPT in November 2022, which has shaped the provisions on GPAI in the regulation. But the concept of disruption is embedded in the regulatory framework of the EU AI Act at a much more fundamental level. Literature has described the AI Act as a hybrid instrument, a two-headed beast. It addresses two dimensions of risks posed by AI, product risks and societal risk. And this tightly connects to the idea of disruption. Product risks refer to potential harm to health and safety. So classic product law issues. They are caused by a specific product. And the underlying logic of this is that the products traditionally possess a fixed physical form, and it remains unchanged throughout their life cycle. For example, toys, lifts, or forestry vehicles. Societal risks, on the other hand, are somewhat less contoured. They relate to the protection of fundamental rights and other European values, including democracy, the rule of law, and environmental protection. The AI Act references AI systems in the area of biometrics, critical infrastructure, or education. Societal risks are linked to the intended purposes and the circumstances and the context of use, all of which can vary. And of course, both dimensions of risks may overlap. The AI Act's hybrid approach aligns well with the concept of disruption. It treats AI as a product. At the same time, it recognizes the societal implications that such products may generate. Let us look a little closer. At the heart of the AI Act's regulatory approach is AI standardization. Once the European standards or implementing acts are published in the official journal, access to the European single market will hinge on a 3-step process. So risk classification, conformity assessment, and CE marking. And notably, private actors will remain primarily responsible for all 3 steps. These procedures make the AI Act particularly complex. And this is what I describe with the term of multidimensional collaborative AI governance. It binds both public and private deployers and providers of AI. They interact in a nuanced manner, a consequence of the AI Act's nature as a horizontal regulation that applies to a wide range of AI systems. The AI Act has the potential to enable 2 crucial preconditions for effectively regulating AI, that is, knowledge creation and exchange and trust building. Both dimensions are currently discussed in various disciplines. As to trust building, the harmonization of the digital single market via standardization heavily relies on the notion of trust. The CE mark aims to enhance trust in the product's compliance with health and safety standards. And, crucially, it remains to be seen whether AI standards will also inspire trust in the ability to protect against societal risks. As to knowledge creation and exchange, AI regulation requires adopting a multi-level perspective. AI regulation needs to pay attention to the interactions between the domestic and the European level, as well as between the European and the international stage. And finally, the AI Act's regulatory approach is supposed to be fast and effective, and therefore well-suited to adapt to the dynamics of technological evolution. This is because harmonized standards do not constitute formal law. Therefore, they can be modified and adapted through a much more simpler procedure, making the process faster. This flexibility also enables industry expertise to enhance the regulatory mechanism. Thus, it enables knowledge exchange. I describe this regulatory mechanism with the term multidimensional collaborative AI governance. It is collaborative as it relies on different public and private actors on the member state and the European level. It is multidimensional as it divides different public policy functions among these actors. And I conclude, multidimensional collaborative AI governance and disruption are closely intertwined. Disruption has been framed itself as a category of knowledge. In light of the foregoing, an informed understanding of both the evolution of the term disruption and especially its normative aspirations today are indispensable for the AI Act to unfold its potential. And this applies to all actors involved in standardization. Only such an informed understanding, and I do not say that this is an easy task, but only this will make the AI Act an instrument of knowledge exchange and trust building in an environment that is shaped itself by the discourse on disruption. Thank you so much for your attention.
Thank you, Anna Julia. We have now a couple of minutes, 5, 6, 7 minutes for questions. So if the audience has questions about the presentation we just heard, then this is your chance. And I also have to say that you have to come to this microphone because otherwise it won't be on the recording. So that would be very lovely if you come here and ask your question into the microphones. While you are still thinking about your question, I have one quick question for you, because I would like to better understand what is the difference between Schumpeter's notion of creative destruction and disruption.
Yeah, I think it's an interesting question, and it has been answered by Adrian Daub in his book. So his claim is to say that there are many notions circulating and being also distributed through social media, actually, which supposed to don't have any history, right? To come like they have been disruption it's from now on, but then he traces their backing and the history of these terms. And as to Schumpeter's creative destruction, he claims that this is much more embedded into Marxist thinking, like it's much more linked to a huger kind of intellectual discourse than this idea of disruption as a desirable force. It's a bit less deep, maybe to say. So we shouldn't make we shouldn't equate them. Yeah. They are not synonymous. That's what I say. But they are really close. Yeah.
Thank you so much. Are there more questions? Also, the panelists have, of course, the opportunity to ask questions among themselves. Otherwise, yes, please go ahead.
Opportunity. I shall, because this is very interesting for me. And also, as we'll see, I think very closely linked to my presentation, so well done to whoever organized and put us together. I wonder if you encountered the term co-regulation in your research, and if you could distinguish it from your description of multi-dimensional collaborative governance at all, because it sounds very similar to me, and I think it's kind of what I'm getting at in my work right now.
Yeah, of course. I think this term of co-regulation is more commonly used than collaborative regulation. I think this is where the both differ, and actually we have also in my team we have established the term collaborative governance by looking at the DSA in the first place, because we were thinking what happens here, and I think it's going on even in a more complex way in the AI Act, is more than just private and public actors working together. Right. Because first of all, private actors are on very different stages of the legislative process, also in setting standards, for example. So this is more complex and also very different private actors. Like when they do risk assessment, when they write the standards, when they do conformity risk classification, and then conformity assessment. So we just wanted to say that this is a little more complex than the for us implied this two players thing, and I think it's more complex, but they are quite close, and maybe one could even apply a definition of co-regulation to our approach. So I don't think the differences are so huge, but we wanted to really highlight this point. But it's a very, very good question, and also a question we are addressing in our research. Yeah.
Great, thank you.
I'm looking forward to your presentation.
Are we having more questions? Yes, please. Would you mind coming forward? Thank you so much.
Morning,
Would you
everyone.
say who you are?
Yeah. So my name is Frank Pelloth. I'm a computer scientist and a professor of privacy engineering and policy-aligned systems. So I'm a technology person. And therefore my question is, what do you see, what is the role of technology people in the whole story, and what should be the role of, or what could be a good role of technology people in the whole story? And the more concrete ideas you have, the better. So give me a concrete example.
Thank you.
Well, in our research group, we have, I said in the beginning, it's when introducing myself, we have this research group, and we have people from psychology, from ethics, law, and governance studies, so political sciences. And we get the question quite often, so where are your technical people in this group? So fair enough. I think it's a legitimate question. Of course, I think also from the CPDP conference, I got this feeling that there is some kind of agency moment, and I don't exclude the tech people, but some kind of agency moment of finding their own discourse in the humanities and including the legal sciences to talk about AI regulation, right? So I think maybe this is this moment where our research group came from. And now to answer your question, what is the role of technology people in the story? Well, I would be super interesting what you understand under the term disruption, actually. So I think that in the first place, I would be really interested if this is something you have maybe a very different notion of it, or maybe not at all. So this, I think in the first place, there would be need for, from my perspective, for exchange. And whether you can take out something of what we are doing. Maybe this is not a specific role, I'm afraid, but yeah, I would be very interested.
Good. Are there any last questions? Yeah? Yes, you would like to ask a question, please.
As a tech person working in the Leiden Law School, I feel your question. I feel we need to be on the table because I do think even in the use of the terms. So your question, what do you understand disruption? Well, something I don't think the tech people wouldn't necessarily think of disruption unless in a technological development. The term is not so meaningful, but the development, which is not disruptive, is very meaningful to the discourse. And also to understand that when people use this word disruption, and this is now something completely new, I mean, I have many people, many colleagues like me who studied mathematics, computer science, early 90s. We're rolling our eyes sometimes when we hear like, this is completely new. No, it's just the same thing with more data and more compute. And so that, I think, is a very important message to be on board with policy shaping.
Thank you for answering the question beforehand. Yeah, thank you so much.
Brilliant. You want to still have a statement? Yeah, but then we have to move on.
10,000 steps, they say, right? So my answer would have been the same, like our understanding of disruption is not that different. I just want to make a suggestion. So yes, I also feel we have to be on the table. And the question is, how do we as technologists kind of, well, come into the game? And we always come into the game through the term of state of the art. And what we do day by day is we shape the state of the art, and we define what can be thought of and what can be like understood as, well, it exists, it has been proven to work, and so forth. And what we would be, I think the same is true for you, what we would be happy about is like, tell us where the state of the art should change and how to make the world a better place. And this is how we could come and shape actually the actual content of regulations.
Thank you. Yes, of course.
So I want to quickly add to everything that everyone has discussed. So my lecturer during the lectures in my school, Sylvia Duconca, said something about disruption. She was of the view that disruption tends to make regulatory interventions quite fast-paced, even where it is not necessary. So when we want to know if a technology is disruptive, we should ask certain questions, right? What is the purpose still there? Has it changed the purpose, or is it challenging to the purpose? And also the value. Is the value being affected by the technology? And if the answer is yes, it's not necessarily necessary that we enact new laws. First, we check the existing laws. Can they be interpreted to cover these new approaches that or disruptions that the technology presents? If yes, then we use them. Else, then we check filling in the gap, amendment, and maybe sometimes creating or enacting new laws. Yeah.
Thank you. And you can also keep the mic, because it's your turn now. Please, your presentation, Rachel.
Thank you. Sorry for my bad manners. I ought to give gratitude to whom it is due. So my deepest gratitude goes to the CPDP.ai team, its partners, and also the sponsors for organizing conferences such as this, that is vital for knowledge exchange, especially such that contribute to the ongoing history of legal innovation. And I'm really pleased to be here. Yeah. So about my paper, please allow me to give you a brief background, because the paper was inspired by a real-life case. It is important for us to recognize the vast possibilities that technology, especially artificial intelligence, offers, while also acknowledging the fatal consequence or the existential risks that come that it presents, especially that which can lead to death. So some months ago, a news story of a young boy who tragically took his own life after interacting with the chatbot, a lifeless object, appeared on my LinkedIn feed. The companion status or friend status attributed to chatbot is quite striking. But unfortunately, this is the reality that we live in. This raises questions not only about our legal frameworks, but also about our ethical principles and the foundation of our societal and psychological construct. But in fact, Mark Zuckerberg recently was on air marketing and advocating for this to be the norm. Although the incident happened in the US, that time I was in the Netherlands studying, so I was curious to understand how prepared the EU was should this type of case arise. That was when I found out that the issue was not unique to the US. In fact, in the UK, in the UK and in the EU, 2 grown men were reportedly to have been in a similar situation. So I just felt that, okay, since the EU AI Act was a hype then, and then it's the regulation that tries to regulate the AI life cycle, so why not? Even though I'm sure other laws may apply. So what is, I would like to briefly give a caveat. My paper was written before the European Commission rolled out the guidelines on prohibited AI practices. While the guidelines address companion chatbots, it was a bit reluctant about addressing the risks. So then I can now tell you about the structure of the paper. I will give you an overview. My paper adopted a doctrinal approach supported by empirical studies, detailing the socio-technical results or outcomes from users' interaction with companion bots. So the paper briefly highlights conceptual frameworks or theories borrowed from behavioral and cognitive science to show some of these, the occurrences of these risks or harms. And it also argued that considering the evidence being provided, the low risk category or classification of companion bots is insufficient because the transparency obligation may not be quite sufficient to address the risks that the paper highlighted. So on that note, the paper found several risks associated with AI companionship. So they range from psychological risk, mental, privacy, and even financial. But the major focus was on the mental and psychological harms. So I should, at this juncture, give certain clarifications. So what chatbot are we even talking about, and in what context or setting? The chatbot that the paper addressed is not all chatbots, actually. There are those that are called or classified as lovers or friends. Those chatbots that elevate loneliness, engage in romantic relationship, and provide emotional support, and sometimes therapeutic support too. All impacting the mental well-being and even overall health of the user. And the setting is those used in domestic setting, because those used in the healthcare sector or prescribed or classified as e-tools may be covered under the high-risk AI and classification, and also other regulations within the field. So because of the context and the type of chatbot in question, the regulatory scrutiny that is available to these chatbots are not as stringent as those in the high-risk category, and which is why I feel there is a regulatory gap there, like a sort of missed opportunity for those types of bots to be classified under the low-risk, so-called low-risk AI system, pursuant to Article 50, Sub 1, conjunctively with Sub 5. So what is the transparency obligation all about? The transparency obligation pursuant to this article and the associated recital 132, is to the effect that users should be informed at the first stage of interaction with a companion, with a chatbot or interactive system, as it calls it. At that stage, it is typical that the information is being provided in terms of services. However, as I've earlier stated, the emotional immersiveness of companion chatbots as it has neurological capacities, and it tends to give unconditional support and conversational persuasiveness while interacting with users. It is not, the chatbot is not in that category of utility chatbot and can go beyond the risks that a normal utility chatbot could present. Therefore, I gave twofold recommendations. So my recommendations are not actually baseless, because they are grounded in the provision itself. Because when you check the provision, it says that the second limb of paragraph 1, that's Article 50, paragraph 1, and also recital 132, noted that while undertaking this obligation, providers should consider the context and the circumstance within which these interactive systems are being used. Meaning that when complying with the requirement, it's important to take account of the category of users. And companion chatbots are in the consumer level stage, I mean in the consumer level, being accessible to even vulnerable users and also the general public. But studies have shown that even for the general users, like everyday users, it's possible that constant interaction with companion chatbots can create new vulnerabilities. While for the vulnerable users, it's possible that it exacerbates those existing vulnerabilities or even make them worse. So the second limb, okay, thank you. The second limb of paragraph 1 also created an exception. I find this to be really undesirable because the transparency requirement itself is lenient, and providers can bypass this requirement if the so-called average consumer benchmark is being satisfied. However, as I've stated, even for everyday user, companion chatbot is able to create new vulnerabilities. Therefore, this challenge that so-called exception that the section provides. Because I do not have much time, I will just quickly outline my recommendations. So the first one is about reclassification or tightening the risk category for companion chatbot. So it could first be prohibited because evidence have shown that it can lead to serious harm, most especially for children. So a precautionary approach is desirable. However, if this is not possible, then why not make companion chatbot to fall under the high risk category? Then the second limb of my recommendation is about extending the requirements for deepfakes under Article 50 sub 2 to companion chatbots. Hence, there should be visual marking for each content generated by companion chatbot. Yes, and also there should be frequent user education banners that educate users, because transparency is not just mere notification, right? It ultimately aims at user education through explainability to be able to give users the ability to assess the risk and to make informed decisions, and also to even challenge the system, the decisions made by the system. So banners should be frequently popped up on the interaction interface, not on the terms of service, because most people do not even read the terms of services, the terms of service. So lastly, I would like to state that although transparency is desirable, it is not the only solution. There needs to be collaborative effort, as the first speaker stated, even outside of the EU AI Act, so from other digital regulations, so that AI companion chatbots can be safe for human to use. And I'm sure most of us recently know about the Italian data protection authority's fine against Replica. That is from the data protection angle, and it is desirable that other angles, such as the consumer protection and even the UAI Act, take such approach. Thank you.
Thank you. Are there any questions about companion chatbots and the current regulatory environment for Rachael? Are you having comments, remarks, and questions? Yes.
Thank you so much. This was very interesting. I was wondering, did you have a look at Article 5? Is there any, would there be a definition of, I don't know, subliminal techniques or something where we could put the companion chatbots, even though this was obviously not the idea of the legislature, but have you thought about this?
Yeah, certainly. As I've mentioned, the paper was written before the European Commission rolled out the guidelines. But from the guidelines, yes, there were certain examples that were attributed to companion chatbots, and it was stated that most times companion chatbots may fall under the manipulative, purposely intending to manipulate users, most especially the vulnerable ones. Because at the end of the day, I feel like companion chatbots are inherently deceptive, because they are meant to take up roles that they cannot even give. They can never give it under normal circumstances. So yeah, it's possible to make this argument. Besides, there are cases where people have committed suicide or were about to kill a certain person because of their interaction with companion chatbot. Even those that are grown up. Yeah.
Thank you so much for your lovely presentation. I think we also share a lot of interest, so I echo the words of thank you to the organizers who put us all together. I was wondering whether you looked as to whether Article 50 specifically is linked to the same notion of average consumer within the UCPD, or is the notion that is used within Article 50 of the AI Act slightly different than what is used within the UCPD?
Yeah, interesting question. Pardon me, I didn't really check it because although since these regulations are like connected and some of them rely on the definitions given in other laws, of course, I would say that the definition under the consumer protection angle is what is considered, or that might be the intention of the drafters. And you know how very controversial it is, right? Yeah. So, yeah, I think it should, it should. That should be the notion because, as I explained, even average users might have new vulnerabilities because of the interaction, thereby challenging the notion of average consumer standard. Yeah.
Thank you.
Brilliant. Are we having another intervention question? Where are the technicians now? The experts? No? Okay. So I also think that is a field that requires much more research as well to be done, to also understand more about the effects on humans when they, for short-term or long-term, interact with machines that are faking relationships. So if you all agree, we are moving on to Emma. Emma, it's your turn. Can we put up? Yeah, great.
Great. Thank you very much. Oh, excuse me. Thank you very much. I'm really looking forward to beginning. So my paper is on technical standards and more specifically co-regulatory technical standards within the AI Act. And we'll be looking at the interactions actually between what I'm talking about and I'd love to bring in some of what Ana-Julia was saying earlier as well. So we'll look at the AI Act and also going to look at what that might mean in a different context. So I'm looking at an EU-US comparison. I'm from the United States and trained in that jurisdiction, so looking at how we might bridge these gaps. And another disclaimer is that my paper was also written in January of this year, or finished in January of this year, before Trump began his term in office, so I'll make some adjustments there to account for that, but please do bear with me, and I'm looking forward to your questions as well. So we'll begin with defining co-regulation. So a lot of scholars define it as regulated self-regulation, and it basically is this idea that regulatory duties should be dispersed across both the public and the private spheres, as Ana-Julia was saying earlier. It is this idea of multidisciplinary, multi-actor, multi-sectoral collaboration. And it's really useful in digital regulation for that reason. It does rely on that collaboration. It looks to seek out, it should seek out the recommendations of technologists as well as policymakers, regulators, lawyers, et cetera. So in terms of technical standardization, technical standards, as you all know, outline those requirements that are required to comply with the law. And we know them to be collaborative and consensus-based, dynamic and flexible, and also that they provide some clarity on expectations for compliance with the legal obligations on the part of companies. So technical standards have long been a regulatory tool in most jurisdictions, especially in the EU and also in the United States. So they're currently used for accessibility, data security, hardware requirements even, and of course the AI Act is particular in that the technical standardization process there is attempting to, is attempting to use them for fundamental rights protections. So that's something that is quite novel about the AI Act and that has not been attempted before. Typically, technical standardization is for product standardization rather than fundamental rights protection. So we'll talk a little bit about that as well. So the technical standards that are outlined in the AI Act, I would describe some of them as co-regulatory and some of them not. So the co-regulation that we do see in those technical standards, there are provisions in the Act which direct norm development by standards organizations which integrate private and public stakeholder expertise. And there are also the use of accountability mechanisms that do require public oversight of that regulatory implementation. And those are really important aspects of the technical standardization that's outlined in the Act that I think are important because they are co-regulatory in that they do have that mechanism of accountability that is based on public oversight. These specifications are set out in Article 40, which directs the Commission to issue those requests covering obligations to the relevant European standardization organizations. And those requests specifically do ask for deliverables for reporting and documentation. So that's that oversight piece as an example of the co-regulation that we're talking about. But there are also failures to co-regulate in the Act. So there are a few high-risk systems that are listed in Annex 3. Some of these are education-based systems, systems for hiring even, and the Act assigns the responsibility to the manufacturer of that AI system to conduct the conformity assessment for compliance, which, as you might imagine, has some issues or potential issues there. And the results of that assessment by the product manufacturer are not required to be published. So there's very little accountability and oversight by a public body there, and therefore it's very likely that there will be a lack of true oversight in those systems. It really matters who is checking the math in these situations for us to be able to call something, let's say, co-regulation, or to say that this was an accountable system. And so in that vein, we're looking also at technical standards for American regulation. And I think the primary question to ask here is why? Why compare the US and the EU in the first place? They're two very different jurisdictions. We obviously don't transplant regulation. It wouldn't make any sense, not just because of constitutional frameworks, but also because of attitudes towards regulation at the moment. And attitudes towards regulation since the dawn of the internet, actually. So this is not a new phenomenon. The United States has not just started saying, oh, we don't want internet regulation. That has been the byline since the 90s. That has been what has facilitated the very self-regulatory regime that has characterized the American legal environment in terms of digital regulation, privacy protection, et cetera. And by self-regulation, I mean, we're going to let industry handle this, hands off, the market will regulate itself. A very American kind of lens of looking at this, and it's very, quote-unquote, innovation-focused. You see some of this rhetoric now, however, in the EU, where we have some of this, oh, but what about competition, and what about, this new, I would like to point out that after Trump was elected, the EU rhetoric did shift a little bit more into this competitiveness. How do we be competitive in the global market? How do we make sure that we, foster this competition and innovation? And so this very, what I would have usually said characterized the American regulatory environment is now kind of navigating it through into this EU discourse as well. And that's quite concerning to me, given that I like to think of the EU as quite the bastion of the fundamental rights kind of framework for things like privacy and regulatory design. So a little bit worrying there. But now that we do have an understanding of how these things cross borders, right? We do have an understanding of if the United States has a position on something, it's going to be very difficult for the EU to have a totally contrary position. The EU seems to kind of see this as, okay, we might be losing out, so we've got to course correct, we've got to kind of take over some ground that we're losing here. But I'd also like to point out that the American political environment is not necessarily the same thing as the American regulatory environment, and certainly not the same thing as American academia and civil society, which has long been pushing for stronger regulations, which has been, really in the trenches fighting for consumer rights and consumer protection in these areas, and was doing quite well before Trump got elected, actually. And you'll see that and if you look at the federal level, yes, there is a dearth of regulation, but if you look at the states in the United States on an individual state basis, they are coming out with new regulatory interventions and new we're calling the states like laboratories of regulatory innovation in the United States right now. We are seeing some movement forward here. So it's not, hope is not entirely lost in that area. But for those states and for the purposes of bridging this gap, I think technical standards are actually a great place to start. We have some barriers there, of course, as well. Typically, technical standards are instituted in the United States by federal regulatory agencies. You might have heard of the Environmental Protection Agency or the FTC, the Federal Trade Commission. All of these, especially the EPA, the Environmental Protection Agency, which has long used standards for things like the Clean Air Act, which was passed in the 70s and is still relevant today because those standards could be continuously updated to reflect the practices of modern sustainability and environmental practices. So all of these things were based on technical standards. The Clean Water Act or Clean Air Act was passed in 1972 and continued to be updated, right? And because the agency had the ability to make those rules, we were safe in allowing them to do that. This was a court, Loper-Bright Enterprises v. Raimondo was a court case that was handed down by the Supreme Court last year, which effectively removed the ability of those agencies to act in that way. And so that overturned Chevron doctrine, which was a case that allowed agencies to enforce statutes or legislation in the way that they deemed necessary. So they brought in experts, created technical standards based on those expert recommendations. They worked very heavily with technologists and environmentalists, et cetera, to create those standards. And that was all perfectly fine under Chevron, and no longer fine under Loper-Bright. So the current regulatory environment is quite stacked against executive agencies and federal executive agencies in that measure. So in terms of Loper-Bright and tech regulation in the context of what I'm going to call Trump 2, we're obviously entering into a very difficult time for any kind of regulation in the United States. It will be very difficult to get past Congress even. It will be even more difficult to get anything on the desk of Trump, much less get him to sign anything reasonable. But there are pathways forward, as I said, in terms of technical standardization, just because it is a more flexible regulatory mechanism, right? So it is more easily updated if it doesn't require explicit agreement of Congress on fine points of things, if that can be delegated out. So a mechanism, for example, if a piece of legislation were to include delegation of authority to an executive agency to develop those standards, that might be a pathway forward. We can also rely on technical standards developed by international organizations, and there are legal provisions in the United States which allow us to do so. So these are really important considerations here. One thing that I do want to reiterate is that in the area of technical standards, co-regulation is key. And by co-regulation, I'm really meaning accountability and collaboration. So the inclusiveness of public interest perspectives in terms of the development of those regulatory standards. So this was trusted when we had those executive agencies that were able to develop those standards and bring in expert opinions. The National Institute of Technical Standards released cybersecurity standards for quantum cryptography in the last couple of months. So if quantum were to be broken at some point, there are new standards for encryption. And of course, that was heavily reliant on technologists to kind of come up with what kinds of mechanisms might be able to withstand quantum. So very much an inclusion of public interest and expert perspectives in the development process, and also then external regulatory oversight of that implementation in jurisdictions that are very prone to regulatory capture, like the US is, and like the EU is not invulnerable to. It's important to remember that external oversight is the key in any regulatory regime, but especially in technical standards, which are a mechanism that can be very easily co-opted. But yeah, Thank you so much.
Thank you. We have time for 2 to 3 questions. You remember that you should come, please, here to the front, if you don't mind. So are there questions for Emma? I have one immediately, but is the audience, you are having priority here. Yes, please come. Please introduce yourself.
Hi, I'm Luca Nannini. I have like several hats. I here for like the Italian NGO Privacy Network, but it happens also that I'm part of the Scienza Nella GTC 21. So basically, the technical committee developing harmonized standards for the AI Act, and I was recently even appointed the trustworthiness framework project co-leader. So I feel a bit of burden being here, like hearing critics, comments, suggestions. I really welcome that. I'd like maybe to ask specifically to what was presented now is like, do you even envision to investigate, for example, market surveillance authorities per Article 74? So like there are different mechanisms that are reported in the Act, and it's not yet clear basically how standards, like harmonized standards, will be checked by MSAs, by market surveillance authorities. Yeah. So like myself, I'm working with them, and sometimes it happens that like they lack, let's say, technical knowledge, legislative knowledge, procedural knowledge. So I don't know what could be your recommendation. Yeah. Thank you.
Great question. Yes, thank you. So as I think has just been pointed out, it's not enough that the standards are checked by an oversight body. It's also important that that body is competent and has the expertise and the relevant knowledge to be able to effectively check the work of these industry partners. If I've understood your question correctly, I think that the EU has, in my opinion, remarkable institutional power in terms of regulatory oversight, a lot more than other jurisdictions, certainly a lot more than the United States. But it will be increasingly important to staff these organizations with technologists, with people who are experts in the field, who can actually speak to what's going on when they have it in front of them. And so, yeah, it's gonna take a lot of infrastructure building, I think, to get to a point where we can effectively say that this is, good oversight. But yeah, thank you. It's a great point.
You had a question?
Would you like to go first? Or?
No, I think we will discuss later. You go.
Yeah, thank you so much for such a wonderful presentation and for looking into this topic. It is really great. And I was wondering if you could spare a few words into how does the integration of civil society organization look like within standardization processes in the US? Because we do know that this has been a challenge within the EU.
Yeah. Thank you so much. Yeah, actually, give me the opportunity to say something that I missed in my presentation, which is that in the AI Act, when they do have the provision for the inclusion of civil society in the standards creating process, the civil society are often just not allowed to talk, right? So they're allowed to be present in the room, but they're not allowed to actually contribute in a lot of cases, and I found that quite amusing, but also a little bit redundant. So it's, I think, not dissimilar in the United States. You have a lot of, and the organization that I am a fellow for in Washington, D.C., we do try to submit briefs and things like this that say, okay, this is our position on this topic, and it's kind of a, throw it up in the air and see if they happen to read it. And of course, you have civil society partners and leaders included in, they're called to testify before Congress when Congress is creating legislation and all of these things. In terms of technical standards development, when standards are being developed, depends on the agency, how that process works. When NIST was developing the quantum standards, I believe that was a collaborative process among many, many partners and stakeholders that occurred over a number of years, and several interviews and all of these things. And I do believe that that was a really inclusive process of civil society. But to my understanding, I was not there, so I can't really speak to that. But yes, thank you so much for the question.
Oh, thank you.
But I think, I'm so sorry, in the interest of time, so that our last presenters also have a chance to have a full quarter, I would like to invite Maria-Lucia and Gianclaudio to give their presentation now, and then we have also time for you and the discussion. Yeah, I'm sorry, afterwards maybe.
Oh, yes, could we have the clicker, please?
Oh, sorry. Yes.
The clicker? Thank you. And if the presentation could please be set up, that would be lovely. Yes. Okay, so we will try to be timely, and I will indeed, that's a good tip, thank you, Gianclaudio. We will try to start. So like I said, my name is Maria, and together with Gianclaudio, we have worked on trying to define vulnerability as a concept within the AI Act, and our paper will be forthcoming in the FACT proceedings, and if we don't have time for all your questions, please do come later on to talk to us. So how will we proceed with this? We will talk a little bit about why human vulnerability is a concept that is important to be understood within the AI Act. Of course, besides the fact that we have the issue with chatbots and the prohibitions, we will briefly go over how and where vulnerability as a term is mentioned within the AI Act, and then we will provide our own criticisms and our own interpretation of the term. You also wanted to add something? No. Okay. All right, so just to start, why human vulnerability, it is important to distinguish that vulnerability is also used as a term for cybersecurity measures, but we are really looking into the way that it's used in relation to humans. And here we have two categories of reasons why we look at this term particularly. The first is that it has quite an ambivalent meaning. So it is something that everyone experiences. It is a perception. It is an emotion that we can all relate to. And at the same time, we have a lot of academic literature that tries to explain to us who is actually vulnerable. So there are different perspectives in telling us everyone is, as opposed to just a couple of people are, as opposed to other perspectives that say, well, everyone can be at different moments and in different contexts. And slight spoiler alert, we will definitely be looking more into the third option I just mentioned. And lastly, in academic literature, the pattern has been that using the term vulnerability within legal processes has imposed a different moral and political imperative to act and to provide aid. So in that sense, the term is used within the law, so within different EU legal instruments, starting from the UCPD, but also outside the tech sector, and most recently in the AI Act, the term is present. The term within the AI Act is a risk categorization tool, as it can make a AI system be prohibited, but also it can help as a criteria to introduce an AI system within the Annex 3 list of high-risk AI, whenever this shall be expended. It is also an enforcement tool in that market surveillance authorities should observe how AI systems affect an individual's vulnerability when implementing the regulation. So where and how is vulnerability used within the AI Act? There are 17 different mentions of the term that we have, I will show you in a bit, classified within 6 different derivative mentions and formulations. And each of these formulations also have associated examples, so over 20 examples that we have gathered of different terms that are again given as an example of what can be vulnerability. Besides despite this importance, we have no full definition of the term. So that is also the problem that we are relatively trying to solve, also looking at the Commission guidelines, which have given us a slight insight. So our categorization looks like this. On the side of the table, you have the associated articles and the references that we have clustered together. As you can see, the term is not used similarly, so it's not only vulnerability, but a lot of times you talk about vulnerabilities of a person or a group being vulnerable as a group, but at the same time, we also look into a vulnerable position. So this, for instance, could mean that anyone could be in a vulnerable position, so it's a lot more universal approach. We have also looked at the examples and tried to classify them along the reference formulations. We have merged some examples, I must say. For instance, we have put socio-temporal characteristics to describe different examples such as status or knowledge or things that are really dependent on the person's background. But we have also then focused our analysis on the notion of vulnerable position and vulnerable groups. We will not be going through the entirety of this analysis right now, but we will offer you our results and insights based on it. So I did say that there is no official definition within the AI Act, but there is a definition that has been provided kind of by the European Commission. And why I say kind of is because it is still open to interpretation in the sense that the Commission itself uses may be understood. So we take that to mean that there is still room to change. And indeed, within standard making procedures, we have been in touch with that a little bit. And there too, we have been asked to perhaps think of a different way to refer to vulnerability. But here I will focus on a couple of things from this Commission definition. And that is that the Commission looks at vulnerability as a type of susceptibility. It can be cognitive or emotional, but essentially part of the person. And that susceptibility can lead to, when mediated by AI systems, when an individual interacts with an AI system, can lead to a behavioral or decisional change. That is, in a nutshell, this definition that the Commission has provided, but we do have 3 critiques. The first is, of course, that by looking only at the individual, we miss a lot of the power relations that are outside of the individual persona. The second is that this, although yes, it is true that the individual behavior can change, you can also be vulnerable if decisions are made about you, even if your behavior itself doesn't change, but then there is a cascade effect of harms. And then the third is that this definition does not take into account the element of agency, control, and resilience that any individual may experience, as well as the opportunities that the law or legal structures give for redress. So we have then developed a new definition, or a proposed definition, which we read as vulnerability being the higher risk to fundamental rights, and that is more aligned with the AI Act's risk categorization framework, since you can think of prohibited, high risk, or low risk. And then we consider that to result from power imbalance dependencies, which are, which Gianclaudio will explain also a little bit later. I don't want to take too much of that. And then, of course, the element that we have criticized, we have included the element of resilience.
So, yeah, we'll be very quick on this table of new definitions that we tried to have. As Maria was saying, we also had the opportunity to help operationalization of this concept for civil society in the standards process, but we're not optimistic at all, because as you see, as Maria was saying, the starting point is that vulnerability is seen as something belonging to you, like a jacket, a hat. It's not that. So if we start from our definition and we focus on the ex-ante power imbalance dependency and the ex-post resilience, usually people focus just on the first element, which is personal elements. And this is also what the Commission does. Can I go back? Health, age, knowledge, language, etc. There's much more. Vulnerability is based on an encounter with a relationality, so it's an interpersonal element. And so we tried to identify how relationship matters a lot in your definition of vulnerability, because it's a dependence. You depend on something or on someone that might have monopoly or oligopoly on the enjoyment of your fundamental rights, but that's not enough. The encounter between my personal characteristics and my boss, my university, etc., really depends on the structural, political, economical, technological, societal, historical elements, like what is the level of discrimination, subordination in society, what is the level of rule of law, what is the market structure, is there market concentration, is there alternatives in the market? All these things influence the definition of vulnerability, which, as you see, is not a personal condition, at least not alone. And then there's the ex-post resilience that we will, also based on personal resilience, but also based on structural element, if the state support, if there are support groups, welfare services, etc. So this is a bit our model that we will present in Athens next month at the ACM Fact. I think now we are done, and it's time for questions. Thank you.
Thank you. Very, very timely paper. Vulnerability has really changed a lot over the last, our understanding of it over the last years. Do we have questions from the audience? Yes, please. Would you mind coming in front, please, for the recording?
Hi, I'm Sue Ann. Thank you for the presentation. I really enjoyed it, and I also enjoyed your reformulation of vulnerability in that way, let's say. I saw that the elements that you put out there, and I can agree with all of them. I'm just wondering about the threshold, right? If you talk about a higher risk to fundamental rights, when does one cross the threshold for it to become a problem? Thank you.
This was the main problem of my PhD thesis, and I tried to solve it with the paper with Kristina Santos about how to measure severity of impact on fundamental rights. But of course, it's not, I mean, this was a tentative solution, that one, so the threshold. So in that case, you first need to understand how to measure, right? Because even if not quantifiably, at least qualitatively, you should understand how to measure severity of impact on fundamental rights to say, oh, this is a threshold. And then, of course, I think the threshold is also when the enjoyment of your fundamental right is, the interference is limited more to an intermediate level. But of course, this is really contextual, yeah? We cannot have a clear threshold. I would say Annex 3 is already a threshold. So all high risk in the AI Act are already threshold. Do you want to add anything?
Yeah, indeed. And I think the higher risk part of the definition also was to really look or to fall in line with what is already within the AI Act. So if we look at unacceptable risk to rights, as they will be then interpreted also by courts and cases, then that would fit also within our definition. High risk, that has its own category, of course, and low risk as well. But what we are also emphasizing, I think, that might change this threshold is this participatory element and the individual's experience. So you might be vulnerable, for example, as you say, as you have mentioned, but because your interaction with AI chatbots is one that is quite intimate, that you might feel more manipulated, and that your experience makes you feel also more vulnerable. So it is equally a structural element, like Gianclaudio is saying, but it's equally a participatory element.
Which brings us officially to the end of this really exciting panel. I would like to ask you for a round of applause, not only for these fantastic panelists, but also for Manus Russos, who organized the academic sessions, for our technicians, our stage manager. Thank you very much.